and repeated his earlier request for action under Article 356. 1. The President issued the proclamation in question, with the recitals already referred to above. The proclamation was thereafter approved by the Parliament as by Article 356. 3. A writ petition was filed on 26 April 1989, challenging the validity of the proclamation. A special bench of 3 judges of Karnataka High Court dismissed the writ petition judgments. The verdict concluded that the power of the President to dismiss a state government is not absolute. The verdict said the President should exercise the power only after his proclamation. Imposing her rule is approved by both houses of Parliament. The court said the President can only suspend the Legislative Assembly by suspending the provisions of Constitution relating to the Legislative Assembly. In case the proclamation does not get the approval of both the houses, it lapses at the end of a period of 2 months and the dismissed government is revived. The suspended Legislative Assembly also gets reactivated. The Supreme Court also stated that the proclamation of the imposition of Article 356 is subject to judicial review decision of the court. Article 356 power on the President appointed on comments made by Dr. B.R. Ambedkar in Article 356. He thought that emergency conditions would be appealed to the most unusual situations, though the court also approved to the proposals of the Sarkaria Commission in regarding the use of Article 356. The Commission suggested that before invoking Article 356, 1, noticed on certain conditions it must be given to the state. Article 356 does not expressly address the dissolution of the legislature. Such powers are employed in Article 356, 1a, Articles 1 to 74, 2b, allowed the government to the Legislative Assembly and the President under Article 356, 1a, delegate the powers and duty to both the government and governors. The court that coordinated power to dissolve the legislature said so. Article 356, 3, once the proclamation to the laid before the Houses of Parliament, the President has the power to refute the legislature under Article 356, 1c, before the consent of the announcement by the Parliament. Conclusion. This case deals with assessing the lawful mechanism and searching the whole area of Constitution imperative on central state relations and the contention's role of state governors calling President rule. The fact under the system of our Constitution great power is discussed upon the center vis-a-vis. The state does not mean that the states are little appendices of the center. The center cannot temper with their empowers. The decision is acknowledged to be an important judgment, as it has put an end to the arbitrary explain its position of state government under Article 356 has to function. The judgment reason that the power of the President is not absolute but in custom power, and the presidential proclamation is not excluded from the judicial analysis. The case of Professor Bommai v. Union of India is a landmark judgment by the Supreme Court of India, delivered in 1994. It is significant in the interpretation of the Constitution of India, particularly with respect to the President's power to impose President's rule under an Article 356 and the principle of the federalism. Here are the key takeaways from the case. First, background of the case. The case arose when state governments were dismissed by the central government, citing reasons of breakdown of constitutional machinery. SR Bommai, the then Chief Minister of Karnataka, challenged the dismissal of his government. The central government invoked Article 356 of the Constitution, which allows the President to dismiss a state government if it is unable to function in accordance with constitutional provisions. 2. Questions of law. The scope and limits of the President's power under Article 356. Whether judicial review applies to the proclamation of President's rule. How the principles of federalism and secularism are protected under the Constitution. 3. Key findings. Federalism. The court reaffirmed that India follows a cooperative federal structure, where both the Union and the states derive their powers from the Constitution. As judicial review. The proclamation of President's rule is subject to judicial review. The court can examine whether the material on which the President acted was relevant and sufficient. Secularism. The judgment emphasized secularism as a basic feature of the Constitution. If a state government acts against secular principles, it could be valid grounds for invoking Article 356. Test of legislative support. The dismissal of a state government cannot be based on the subjective satisfaction of the central government. The majority of a government in the state assembly must be tested on the floor of the House CAQ, not elsewhere.